The Honorables, the presiding judge and judges of the Court of the Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. I'm Richard Dietz, and joining me on the panel today are my colleagues, Judge Hunter Murphy, Judge Allegra Collins. Also joining us in the courtroom, our clerk, Roderick McFarland, and our deputy marshal, Richard Remillard. We have one case on the calendar for argument this morning. That's number 22-384, Jayawardea versus Daka. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Thank you, Your Honor. May I reserve 5 minutes for rebuttal? Is it okay if I have my laptop up here? Didn't want to. Okay. Good morning, Your Honors. Lamar Armstrong for the appellant, and with me is the trial counsel for the appellant. If I call him Dr. J, that's sort of his commonly known name, and what's referred to him in the briefing. And so I'll start first with the issue of the purchase of Dr. J's shares in Fern Creek, the cardiology practice. And there's two overarching main reasons why summary judgment for the defense on that issue was incorrect. One, this is something covered thoroughly in our brief, so I won't spend as much time on it today, but there's no competent evidence to support that ruling. In fact, the only competent evidence is that of the value of Dr. J's share was provided by our expert, Mr. Crawford, with his affidavit and his report. And so there's no competent evidence, but number two, even if there is competent evidence that supports the determination in the defense favor, because they rely on this thing they call the calculation report on this issue. So even if that is competent evidence, the defendant's evidence of the record is the defendants didn't follow their own document. Document meaning the shareholders' agreement. Shareholders' agreement, as explained in brief, has a provision in it, the buy-sell provision, which provides a very basic, simple formula for calculating interests in the business in the event of a buyout, in this case, Dr. J's buyout. So first, no competent evidence other than Mr. Crawford's valuation. Number one, there was no expert disclosure by the defendants of anybody. This calculation report was purportedly drafted by a Mr. Farmer. No sort of authentication of who Mr. Farmer is, the credibility or accuracy of his opinions, so on and so forth. The trial court was just handed a document without any sort of disclosure of who he is, what opinions he's going to provide at trial, and what the basis of his opinions are, the very things that you have to do under the expert disclosure rule. Defendants understanding this tried to get around that, saying, well, he's not an expert witness, this report's not an expert report, but I think anybody who's ever tried a case, and certainly anybody who's reviewed expert reports, can review this calculation report and see that it is in fact an expert report. It plainly provides experts' opinions, rationales, bases, methodologies. There would be no reason to call whoever Mr. Farmer is or anybody else to establish a value or evaluation of Dr. J's shares if it weren't for an expert testimony reason. Expert testimony.
I understand, though. I think
yes, sir.
The argument from your friend, I thought, was we don't have to have a trial on valuation. The contract provides how we'll determine the valuation. All we're doing is presenting the evidence of what our part in that contractual process was. So that's why it's not an expert. Am I wrong in understanding that's their argument?
So a couple things. One is they argue that that's not what they did. But the second thing is that, and I'll get to that, the second thing is Rule 702 is what governs expert testimony. So we can call somebody a fact witness or an expert witness all we want to, but in fact, if it is offered to help or assist the trier of fact based upon one's education, training, experience, then it is in fact expert testimony under the rule, whether you call it that or not. And so here they produced this 10 to 12 page report that does exactly that. It would be, I mean, you would have to call someone to explain what calculation they're making, why, what methodology they're using, because if you just provide a number without any context, which is not what this report does, then it's incompetent on other bases, but so it is by necessity expert testimony and an expert report.
Well,
yes, sir.
just clarify that in part of Judge Deet's question too, maybe is part of the same, but if the contract calls for methodology and they say, this is that methodology, this is that equation, this is that variable, here it is, then my understanding of the agreement is that's not going to need to be proved at trial. You might be able to claim it was in bad faith or fraudulent, things like that under the agreement. And then that, burden's going to be on you, but all they have to do is give a number. I mean, it could be, we're going to ask 3 people on the street what the value is, and whatever their average is the value. Parties agree to that in their contract. So having it have to be an expert opinion of what that valuation is, I don't see as a requirement of the contract. Just because somebody backs up their work or shows their math doesn't mean that it was required to. So can you talk me off that point a little bit, or tell me if I'm missing something on how the contract functions?
Yes, so one, and I'll go to that first. If you take their argument as true that you just look at the contract, you don't have to do anything to prove that book value is actually the number you're giving. And the contract just says you provide a balance sheet for the right time, the last quarter in before the valuation date. You look at the book value that's on the balance sheet, you give us that number. Even if we accept as true that you don't have to have expert testimony to do that, that's not what they did here. And so what they did, again, they say, well, you look at the contract says book value as shown on the balance sheet, but they didn't give us a book value as shown on the balance sheet. They gave us a 12-page report. And in that report, it specifically says, well, part of the calculation that we're doing is discussing and obtaining information from the other defendant doctors, management. And that discussion, you put the pieces together. I'm happy to cite to record citations if needed, but you put those pieces together. It's clear what they did, and I think they admit this, is they went to the other defendant doctors. Defendant doctors told somebody, we don't know who, because it hadn't been, there's no competent evidence of how that happened, but defendant doctors go and they say, we say here's our estimate of accounts receivable. Here's our estimate of uncollectible percentage. Trust us, Mr. Evaluator, whoever that is. These are the numbers, use these in your calculation. That's not what the contract says. It doesn't say you get to go talk to management or pull from outside sources. You're supposed to just look at the balance sheet that's there, and if there's not one there, you make one, and you give us the book value. So they violated their own document by going beyond what it says. And you read this alleged expert report, and it talks about things like an engagement letter. I mean, it even says valuation multiple times in it. It talks about affirming that what was done is according to GAAP, generally accepted accounting principles. How would this Mr. Farmer know whether something was or wasn't done according to GAAP or according to other industry standards if you weren't an expert? You can't just say that.
Back up. So you said if there was not, you would go to the balance sheet, and if there wasn't a balance sheet, you would make one. Is that what they did in this instance?
They did that, but they went beyond that, because they went beyond, they went and they obtained information from the other doctors, and they took their information as true. They didn't check any of the source records to confirm the accuracy of those numbers. And we've got our experts saying that clearly violates basic industry standards to do that. And so, but another thing, Judge Murphy, that you mentioned is the other thing that it says in the buyout provision is it's got to be done in good faith. So at minimum, even if you think that they followed the process, technically speaking, in terms of creating a balance sheet, looking at the number, and you tell us what book value is, and we sort of put blinders on and don't say, well, we can't do anything to evaluate whether they've actually given us book value. And isn't that really the bottom line? We need to know what book value is.
But you don't need an expert, if you have a number,
Yes.
you need expert testimony to show that you're acting in good faith, or is that just potential rebuttal evidence? at that stage for your expert or your allegations that they were acting not in good faith?
No, I think good faith is something that's dependent upon the circumstances. That's a factual inquiry, and that's another way that the trial court, I think, got it wrong here, is because you got, at minimum, conflicting evidence. I would encourage the court to look at Dr. J's affidavit in the record, and you compare that to the initial March 21, 2018 letter from defense counsel saying, we're terminating the employment agreement, we're invoking the buyout clause because of all the following bad things we say you did. Well, he's got this affidavit in the record saying, not only did I not do those things, quite to the contrary, here's what happened. So you've got, at minimum, conflicting evidence on what happened, and how a jury resolves what happened feeds into whether or not a jury believes that they were acting in good faith. I mean, you've got plenty of history here that talks about them holding secret meetings without Dr. J, including just a few days before sending that termination letter. That one he may have been, and that one actually he was involved in, but he was told going into it, we're going to actually talk about the financials. Because keep in mind, he had been demanding for months. In fact, several months, show me financial records. You say, I'm concerned about what's going on. He explains all that in his affidavit. Show me the financial records so I can evaluate, because I'm a part owner. I'm entitled to see, what the practice is doing and how well it's doing, and do I have to be concerned? And they delay, they avoid. Finally, they say, we're going to meet, we're going to talk about financial records. And instead, he gets into the meeting, and they ask him, in fact, demand of him that he take the fall for a pending wrongful death lawsuit that he has no liability for. When he refuses to do that, just a couple days later, they send this letter coming up with these other reasons, all of which he shoots down in his affidavit as to why they're terminating him and why they're forcing his buyout. So there's so much more I could talk about given more time, but just review his affidavit, review the circumstances leading up to that letter that we explained more in brief, and it's clear that there's at least conflicting evidence on the issue of good faith, why they did what they did. Were they genuinely concerned about him going out there and stealing a bunch of patients and a bunch of business and their employees, or were they doing this because out of retaliation, because he refused to take a fall for a lawsuit that he had no responsibility for? So, and I will also note for the court that the trial court did actually deny defendant's summary judgment on the issue of our claim for wrongful termination in violation of public policy. And so it seems internally inconsistent where you're saying there's issues of fact about whether the reason they terminated my client, which is part and parcel with invoking the buyout, whether that was done in good faith or not, or whether that was done for some reason that violates public policy. Specifically, we're firing you because you're not agreeing to provide, perjure yourself, provide false testimony to cover the practice and the other doctors. That's Dr. J's story. Of course, their story is different. But again, that's why you got two conflicting stories, two conflicting sets of evidence. There is at minimum issues of fact on that issue. Jay, I'm sorry, before I go further, have I answered Your Honor's questions on those? So, another part of the issue of the buyout, before I move on, is was it done by the regular company accountant? It's got to be done, the book value as calculated on the balance sheet, done by the regular company accountant. And it's either regular accountant or company accountant. I think it's regular accountant is the specific language. And the evidence of record, we asked Dr. Daka, one of the defendant doctors in his deposition, who's the regular accountant? And he identifies Joel White of this Cherry Beckert firm, and then Cindy. He didn't provide a last name, and I don't think that's ever been clarified, both from this Cherry Beckert accounting firm. Did not identify Stephen Farmer, the one who did this report. So just that in and of itself is, if we're going to hold.
Wasn't the report done under the umbrella of the accounting firm, not necessarily the individual accountants? And wouldn't the accounting firm satisfy the regular accountant?
It's a good question, Your Honor. I think that's where you have to focus on the language. It says regular accountant, not regular accountancy firm or firm. An accountant's an individual, just like a lawyer is an individual. A law firm is not an individual. This isn't one of those legal fictions where you say a corporation is treated as a person for jurisdictional reasons or whatever. We're looking at a contract and saying, what do these terms mean? As your honors are well aware, you got ambiguous, at minimum ambiguous terms in a contract. You can't decide things as a matter of law, summary judgment. And then, again, the whole point of all this sort of holding a microscope over this buyout provision is, what is book value? Tell us what book value is. It's supposed to be a simple process. You look at it, you tell us what it is. But all of the inherent and built into all of that is that it's actually an accurate or somewhat accurate number that's based on reality, not fiction. I mean, they couldn't just go to somebody on the street corner and say, give me a random number. 0, that sounds good. Put it in there. We'll put it in a balance sheet. Yep, we're calling that book value. Because at minimum, that violates the good faith, the implied term of good faith that everybody to a contract has to abide by, whether that's explicitly said in there or not. Here it is. That's by North Carolina law anyway, is you can't just, in performing a contract, just do things in bad faith or that lack good faith. And so here we've got hard, indisputed evidence, or at least they've not disputed it, that the accounts receivable number that the doctors gave their so-called valuation expert and the uncollectible percentage they gave their valuation expert weren't just a little bit off, they were way off, and they fundamentally changed the numbers. I'd encourage your honors to look at the Hank Crawford affidavit.
Getting back to our earlier question, I mean, if we think the parties anticipated that it could be difficult to value the business and so provided a contractual mechanism to do that.
Yes, sir.
Why wouldn't we focus on how does the contract resolve the question? And if we think, because a lot of what you're describing sounds like the types of things that we see in many cases in the battle of the experts between two valuation experts. And I think what we're going to hear from your friend for the defendant is the parties to this contract tried to make sure that would never happen by saying in the contract, here's how we'll deal with it. So what's your response to that?
Yes, sir. Good question, Judge Dietz. So the difference here is this isn't a matter of experts, again, even assuming we have experts on both sides, disagreeing over expert things like methodologies. Here's how we're supposed to depreciate an asset. No, here's how we're supposed to depreciate an asset. This violates GAAP. No, it doesn't violate GAAP. This is not an expert dispute. This is a dispute over, not even a dispute. It is a fact looking at a document. Here's what accounts receivable historical numbers are. And our expert saying it was improper to not actually go to the source records and pull those facts, indisputed facts. They've got nobody to say to the contrary. So this isn't an argument over methodology of, well, you're twisting the numbers to do this or that. It is an indisputed fact that they did not use the actual numbers to come to an even halfway accurate book value number.
But so let me just walk through the process. Like, suppose the next day after that report, your client submitted a report that said exactly what you just said. The actual valuation number should be this because you did the valuation wrong, you didn't go to the right source numbers, et cetera, et cetera. So then under the contract, what happens next?
Well,
Day 3, what would they be doing?
Well, under the contract, they've invoked the buyout, so they've got a certain amount of days to provide an appraisal of what they say is book value. Then we have a certain number of days after that to provide ours, and then ultimately, I think the process is, and I could be confusing this with the LLC's operating agreements, but there's a third independent appraiser appointed who then comes to a decision, but we were never able to get that far.
Right, but that was sort of what I was getting at, is doesn't that, though, that process suggests that the parties anticipated that something like this could happen, and then said so, and if it does, you've got two different valuations, it won't be resolved by a fact question that's resolved by a fact finder in court. The two appraisers will select another appraiser together who will make a valuation and will be stuck with it. Do you disagree with that?
Partly, respectfully, because, well, number one, that process was never followed. We never got the records we needed to be able to give our appraiser information to get an appraisal done. And then once that happened, that only happened because they forced us to file a lawsuit to get records. We get records in the lawsuit, then eventually, yes, we do have Mr. Crawford do his own appraisal. And then next thing we know, they file summary judgment, not us, they do, and we're in front of a judge, and the judge is being asked to accept this one unauthenticated expert report or analysis, but disregard theirs. So I agree with Your Honor. If it had happened the way that it's supposed to happen, there would have never been the need for a lawsuit. There would have been records provided. There would have been appraisals. There would have been a final determination outside of court.
So my follow-up to that is, what was the trial court, when the court concluded here that, because suppose we think what should be happening here is that provision of the contract should be followed. What was the trial court's reasoning for concluding that the process, you could cut off the process as a matter of law now because your client just didn't do what was required for that second step of the three-part? If part one is appraiser, then your counter appraisal, then potentially, the mutually agreed appointed appraiser. What's wrong with the second step for you?
The trial court, I think I understand Your Honor's question. The trial court didn't provide its rationale for why it
What I'm getting at is, was a waiver? Is there an applied term in the contract that creates a time limit? Where was that? Where did it come from for the trial court? Do you know?
I don't. The trial court just says, we're looking at this document. It says book value, so I'm bound under the contract to take it as it is, regardless of all the evidence to the contrary. So the trial court didn't even get to the stage of evaluating, was this document, was this contract, was this buyout provision actually followed? It was just a simple, here's a document, I'm going to ignore authentication requirements, expert disclosure requirements, it has a number on it, I'm going to accept it as true, ignore evidence to the contrary. I wasn't there at the summary judgment hearing, but that's my understanding, Your Honor. Before I move on, do Your Honors have any other questions about the buyout issue? So the bottom line with that, and I'll move on, is you got to have information when you're trying a case. You got to know who are they calling, whether it's a fact or expert witness, who are they calling at trial and for what purpose? Give us the information. They failed to do that, and even the trial judge acknowledged that, which is why the trial judge excluded their last-minute supplementation 1 or 2 days before the summary judgment hearing.
One more question
sir.
for clarification then. So do you think the trial court believed that what happened is we came in with our expert, our appraiser, here's book value. Then there was a contractual mechanism that would have allowed your client to say, I want to go further here. I've got a counter appraisal. And then, the contract goes on from there. But the trial court determined none of that ever happened. It stopped at step one. Here's the appraiser's book value, and we never got to step two. So that's why I can enter judgment as a matter of law. Is that what happened?
It's certainly what it appears, and of course to do that would mean, not to belabor the point, that the trial court accepted as true this unauthenticated, unverified document on summary judgment, which is, as a matter of law, is an error of law. Can't do that. So moving on then, Your Honors, I know my time is a little bit limited. This other issue, a breach of the LLC and the PLLC, which are the urgent care operating agreements, I think it's interesting to focus on that throughout the briefing and arguments, the defendants never addressed the failure to provide records or Dr. J's repeated request for records. It's sort of just, well, we provided appraisals, you never provided your appraisals, so we're done as a matter of law. But again, it's a different issue, but it's sort of similar to the one we were just talking about. It goes back to the good faith requirement. Yeah, we never provided, not never, we were delayed in providing appraisals because we didn't have the information we needed, and in fact, Dr. J was entitled to, both under contract and under the law. There's that provision of the LLC Act that says you're entitled to request records, and we did that. And they said, no, we're not going to give you records. And so violating the law, violating the contracts, the operating agreements, didn't give records. It was error for the trial judge to ignore all that evidence and just say as a matter of law, well, you violated the operating agreements when there's substantial evidence that whether or not Dr. J did, which again, we dispute if he did, we cover that with his affidavit mainly. But even if he did, there's evidence that that the defendants violated the operating agreements too, and violated North Carolina law.
Let me ask you a question real quick on the importance of those documents. To me, intuitively, it seems, yes, to do a good appraisal, you've got to have all these documents to actually figure out what the truth is to do a good appraisal. Is there anything in the record that, you know, obviously with this bulky record, maybe I've missed it, from your licensed appraiser or an expert making in an affidavit or sworn statement that these documents were required to perform an appraisal by his guidelines, or that I had to have these documents to be able to give an appraisal under the guidelines, or licensing requirements, or whatever's required to give an appraisal? Is there any statement from your appraiser to that?
I do think that Mr. Crawford does address some of that in his affidavit. I don't know that he lists in detail every single document he needed and he received to perform his appraisal, but I think part of that is again good faith, which is a fact issue, which is to evaluate book value, you don't need to be an expert to know that to evaluate a book value, you got to have records that show what book value is. I mean, that seems to be common sense, which I think when you pair with what Hank Crawford says, is certainly enough. But again, you know, it's amazing. You look at the defendant's answer here, and this isn't something that I'll point out really quick, and then I'll sit down. Is they've got defenses, record page 304, failure to mitigate, and others where they're saying, you know, you didn't do what you needed to do to mitigate consequences or whatever, and it's like he was trying to get these records for all these years, all this time, and you prevented him from doing that and forced him to file a lawsuit to do that. So that seems to be yet further indication that there's an issue of fact here where they're raising a defense for failure to mitigate, but their actions are exactly contrary, like preventing him from or allowing him to mitigate. I realize, Your Honors, that I have not covered our other issues on appeal, fiduciary duty, and the first issue in our brief on the failure to replead counterclaims. Happy to briefly address if there's a burning question that anybody has about either of those issues, if necessary.
You can
Thank you,
reserve your remaining time for rebuttal, and we'll hear from the appellee.
Good morning, Your Honors. May it please the Court. My name is Jeremy Sugg. I represent the appellees in this case. It is my impression that the most significant issue before the Court today is the fiduciary duty issue, so I do want to try to quickly get to that. Certainly the one that I find the most interesting, but I do want to very quickly try to address some of the points that counsel just raised on these other issues. So first of all, in terms of Mr. Farmer's report and whether that was properly before the court, at one point he referenced Rule 702 of the Rules of Evidence. That's a trial issue. The applicable rule here is not Rule 702 of the Rules of Evidence. It is Rule 26B under the Rules of Civil Procedure. We're not in trial at this point. We are still in pretrial litigation. 26B makes it very clear that there's no obligation to designate as an expert someone who was not retained for the purposes of providing an opinion at trial, someone who was, you know, even if they developed an expert opinion, they developed that opinion in the course of the normal course of events, not because they were going to be called to testify at trial. Now, whether they are eventually called to testify at trial, that's irrelevant under Rule 26B, and the comment to Rule 26B makes that very clear. Turner and Lale have both echoed that repeatedly, and that's very well settled law.
So if my understanding that you're correctly, so your argument is essentially the buyout provision in the contract required an appraiser to do certain work for your clients at the outset, and you're just saying this testimony and this appraisal report are just facts. They're fact evidence of a provision in a contract that was triggered and then something happened. And all we're doing now is saying, here's the evidence that this thing in fact occurred.
Exactly. The contract says we're supposed to have our regular accountant do the calculation. We had our regular accountant do the calculation. We sent you the report, 6 months before you filed a lawsuit against us.
So what's
There's
your
the
view
report.
on if questions like, is the person who actually performed the work, the regular accountant as that term's defined in the contract, is this actually a book value appraisal, those sorts of things? Are those fact questions that have to be resolved by a fact finder, or are those questions of law and interpreting the contract, or what's your view on who gets to decide those questions?
I would say they are questions of law, and I don't see how the trial judge could have found otherwise that this is book value. And it's not as if, book value that you can actually just take, 2 balance sheets and say, okay, here it is, here it is. There were both sides here, both of the folks who did the calculations here recognized that there were adjustments that had to be made. Because the accounts were kept on an income basis, they had to be converted to this other basis. And so there were adjustments that had to be made, and the contract itself recognizes that there are going to be adjustments made. So that's all part of the contract. And so the dispute they have fits into that area between making those adjustments. And they say, well, you shouldn't have used this number that was actually on the balance sheet. You should have used this number that came from some report that the doctors ran. That's not the number that's on the balance sheet. They're making all sorts of unfounded assumptions about how we get from one number to the other. And they've suggested that the doctors gave the accountants this number. There's no evidence that the doctors gave anybody any numbers. The only testimony in the record about how the accounting is done is that there's a bookkeeper for the corporation. She gives the accounting firm the information that they need, and the accounting firm prepares the financial reports. So the assumption that they're making is that not only the bookkeeper but the accounting firm were somehow in on all of this, that they were going to cook the books. And remember that the reason these contracts, these agreements, say we're just going to use book value because that's a simple, easy number that we can trust, is because book value isn't prepared just for the purpose of determining what a buyout amount is going to be. Those are financial statements that are kept for numerous other purposes, including reporting to federal tax authorities and all sorts of other things. So we can trust that these individuals are acting in good faith to report the correct number to the accounting firm, and the accounting firm is acting in good faith to put those numbers on the balance sheet.
So when we talked earlier about how the contract provision sort of anticipates the 3 steps. So there's the appraisal, a counter appraisal, and then...
Yeah, so there's some confusion there in terms of the corporate buyout, the share buyout versus the LLC. The corporate buyout doesn't have any other steps. It's very clear that, so it says book value will be, per the balance sheet, is, quote, binding and conclusive on all persons if it is prepared by the regular accountants in accordance with generally accepted accounting principles in good faith. The record establishes that Cherry Beckert was our regular accountant. He referenced some testimony where Dr. Daka was asked about who his contacts were at Cherry Beckert. And in that very testimony, the question was, oh, we've already talked about this Mr. Farmer guy. Who else were your contacts? And that's when he named Cindy and the other fellow. So, the idea that it had to be this person who they specifically dealt with every day, that's not envisioned in the contract, and that's not the way that the other cases that have addressed this issue, that's not the way that they've handled it. They've looked at it on an accounting firm basis. They refer to the accounting firm that was the regular accountant for those corporations in those instances.
Given the delay in how long it took for them to provide this supposedly simple document that's just based on finances, why shouldn't we imply that the jury could find bad faith in having to take so long to potentially cook the books? Why can't they argue that to the jury, that that's indicative of, some type of collusion or actions in getting a cooked book value?
I think that would be a very difficult inference to draw, to say, again, if you look at Mr.
What inference can we make that there was good faith? As a matter of law, this was done in good faith.
Well, so to prove that they have to prove that it was not done in good faith.
Right,
So
but
the
that's a
presumption,
burden of
I think
proof.
sorry.
We're talking summary judgment, we're talking about burden of production, as opposed to burden of proof. So, isn't this some evidence of bad faith that takes so long? There's different mechanisms being used in terms of percentages. Why isn't that enough to get to the jury? It might not win at a jury. I might not buy that if I'm sitting on the jury, but there's a lot of things juries do that I don't necessarily want to have gone along with.
Well, so even looking at it in terms of burden of production, if they haven't forecast any evidence that there was bad faith,
Isn't the fact that the follow-up letter on May 16th saying you're going to get this valuation report and a delay in 6 months, a forecast of evidence that the balance sheet wasn't being kept and that they had to somehow make one, and then they went around and asked, how did you make this?
No, Your Honor. So that letter says, I think you'll get the calculation. So it's not just a matter of creating a balance sheet. It's a matter of doing the calculation, which again includes those adjustments that I referenced. There could be any number of reasons that it took Mr. Farmer the amount of time that it did for him to prepare that report.
Sure, but isn't that at least some evidence that perhaps that the books weren't being kept as they should have been and that they had to make something in order to give them a report?
I would obviously argue no. So I would also point out, though, that the contract itself envisions that there may not actually be a current balance sheet. There are points in time where the books haven't been finalized. The accountants they're not creating a new balance sheet every day. These are things that take time to do.
But it goes back, if I remember, the contract to the end of the previous quarter, not some ongoing. So isn't the accountant having a quarterly balance sheet already done? I'm just thinking, running my own small firm, it would take me 10 minutes to go into QuickBooks and run my balance sheet from the previous quarter. So 6 months, obviously it's a little bit more different, or a little bit different than a small town law firm, but why isn't there at least enough to say this delay is fishy?
Well, so again, I would just point out that it's not just a matter of preparing a balance sheet, it's a matter of doing the calculation. And I can't tell you, when Mr. Farmer was hired. So I'm sorry, I don't.
Well, it would have been as regular, if we go with your client's position, he was their regular accountant at the end of that quarter.
Right. I shouldn't have said hired. I meant when he was asked to perform this calculation, when this task was given to him.
And aren't those things a jury might need to know to determine this?
Again, Your Honor, I don't think that that's the intent of the contract. I think the intent of the contract is, look, if our regular accountants are preparing these based on the information that they have in the normal course of business.
But the other side never negotiated away their ability to challenge that, to say that this wasn't done with GAAP procedures, that this wasn't done in bad faith. That's also part of this contract. There was never a contractual provision that whatever you say that number is, your account says that number is, I'm going to take it. Contract specifically calls for these other exceptions to challenge that. So why isn't that something that has to be determined by a jury if, in this situation, when they've at least met their burden of production potentially?
Well, so I would just refer back to the prior cases on this point. You know, there are lots of other cases, Crowder and EHP, which were both cited in our case, that reference those same sorts of issues that were presented at the summary judgment stage, saying, you know, well, we don't agree with your calculation. And the court very clearly said, the case that is most on point, while I recognize that it's unpublished, is EHP, and it has this very strong language in it that says the calculation that's performed shall be binding and conclusive, and that's the same language that we have in our agreement. You know, it's almost as if attorneys in North Carolina were paying attention to what the Court of Appeals was saying its in opinions, and they were crafting these provisions in buyout agreements to make it such that we avoid these sorts of issues and return to the process that the court first recognized as being desirable in Crowder, which is we need a quick, easy process where we can look at what book value is and say, okay, that's the number. We're not going to go back and forth with, you know, repeated disagreements about how the calculation was done and so on and so forth. So,
Let me just add from a policy perspective. If that's the perspective of the industry, then do we, either us or the Supreme Court, need to take another look at Crowder if that's now inviting the potential for fraud? If this is so ironclad that one side gets to say what the value is based on this language of this previous case, and now we've had this unintended consequence that now fraud can come into it and there's no relief from trying to prove to a jury when there's been fraud or bad faith?
So Crowder already accounts for the potential for fraud because one of the very first cases in this line of cases was one in which there was evidence that assets had been concealed during the process of an audit upon which the accountants relied. Now, in that case, there was not this language saying that you have to rely on the balance sheet. It left it open to, you know, what the accountants would rely on to come up with their figure, and they relied on an audit, and there was evidence that when that audit was performed, assets had been concealed. So Crowder already accounts for the potential for concealment of assets. There's no indication.
We're dealing with 22 years now of changes in what we expect from accounting firms, what we expect from corporations, and having the wool taken off our eyes, and that there is a ton of fraud. There is a ton of problems in this industry in general, and especially when it comes to big dollar amounts. So is that a problem, or is that a consideration of Crowder that is still any good 22 years later when we've seen all these problems develop?
I don't think that's a problem with Crowder. I think, you know, if that were to be addressed by anyone, that would be addressed by the parties to the contract. If they agree that, hey, you know, I'm not going to put my faith in an accounting firm because of these issues, then they can choose not to negotiate to agree to this sort of language in a contract. But when the parties have agreed to that sort of language in a contract based on the law as it exists in North Carolina, you know, I think they are, you know, permitted to rely on that language being enforced. And, you know, certainly parties in the future may decide, well, we don't want to take the risk of an accounting firm, you know, doing something wrong. We're going to choose to do this a different way. So just briefly going to the issue of whether the farmer report was properly before the court, again, the applicable rule there is Rule 26B. You know, they've made these arguments about whether the report itself was properly authenticated. That's kind of a last-minute argument. Their initial argument was, oh, well, he wasn't designated. We responded in our brief and said, Rule 26B4 is what applies here. We didn't have to designate him as an expert. So now the argument has shifted to, well, you didn't authenticate it. There was never any question about who Mr. Farmer was, where his report came from, or anything about him. His report includes a certification that he has to sign as a member of the AICPA. It explains, as they acknowledged a moment ago, it explains in detail the methodologies that he followed, the documents that he relied on. It has all the same information that a report under Rule 26 would have. They referred to his report and explained it in detail to our witness during Dr. Daka's deposition. And so it's only at this...
Authentication they're talking about, I am the general accountant.
I'm sorry?
Would the authentication be, I'm the general accountant for this business, and pursuant to this contractual provision, the business requested that I perform a appraisal, and is there somewhere in his, where he provides that in an affidavit or deposition testimony, that's to sort of button that up?
Not in an affidavit or deposition testimony. Well, in Dr. Daka's deposition testimony, he said, oh yes, this is the report. We asked Cherry Beckhart to do this, to do the calculation, and this is the report that we got back. But beyond that, Mr. Farmer's report, states that he is an employee of Cherry Beckhart, and that the balance sheets that he relied upon were prepared by Cherry Beckhart, the Fayetteville office. But I just want to quickly address the Food Line case that they cite, because essentially what they are arguing is that we are at trial. They are saying that we have to lay a complete evidentiary foundation at the moment of a summary judgment hearing, and that's not the case. The Food Line case, the reason that the court was not permitted to consider the internet printouts in that case was because those would never come in to trial. There would never be an instance in which a computer printout from the internet would be admissible in evidence to prove that Delays America was responsible for a particular Food Line store. And the language in that Food Line case acknowledges that when they held that, thus we conclude that the documents cited by plaintiff were inadmissible at trial and were probably ignored by the trial court for this reason as well. And there's plenty of other evidence. We cited some case law in our brief that makes it clear that the materials that can be considered in the discretion of the trial court at summary judgment include documentary materials and, quote, any other materials which would be admissible in evidence at trial. So the question is not, have you laid a complete evidentiary foundation at this moment through affidavits or otherwise, but once we get to trial, is this something that you're actually going to be able to get into evidence at that point? I did not think that was a serious issue, so I did not brief it extensively in our brief, but I'm happy to provide supplemental briefing that makes that point abundantly clear. And I do, so again, there was some confusion earlier in terms of the issue with the share buyout versus the LLC buyout. The share buyout is the one where the language says our accountant does it and that's it. The LLC buyout, the operating agreements in that case, provide for the parties to either agree on a single appraiser, or if they can't agree, then we pick one, they pick one, and then that appraiser picks a third one. So we had ours. They already had our appraisal report for the LLCs at the moment that we sent them written notice saying we want to exercise our option to proceed with the buyout of your LLC interests. At that moment, their obligation was to have their appraiser, whoever they choose, get into contact with our appraiser and choose a third appraiser and do the appraisal. Judge Murphy, you hit the nail on the head when you said, well, do we really have to go through, or is there any indication from the appraiser about what documents they needed? Because the contract does not envision a long, drawn-out litigation process of getting every document under the sun that may or may not be useful to an appraiser. The contract envisions that we put this in the hands of the appraisers, and if there's documents that they need, you know, their appraiser could certainly have worked with our appraiser to get whatever he needed. Our appraiser obviously had what he needed to do the appraisal. They can work together to make that happen. To, you know, go through a 2-year litigation process and then say, okay, now we're ready to move forward, the court said, you know, that's not participating in this process in good faith, that's the breach. So that's where he's saying we're gonna cut it off, and the appraisal that you have is the one that will stand.
But what's the contract provision that you submit an appraisal, it's not accepted, it's not agreed upon. So then you go into this 2-appraiser process. What's the default then under the contract terms if the other side just didn't respond at all, but did not accept and agree to the first appraisal amount?
There is no default under the contract terms. I think the analysis that the trial judge went through is, you know, you have an obligation to participate in good faith in this process, and, you know, delaying for 2 years is not participating in good faith. That's a material breach. You know, we now have no obligation to comply with the contract further.
Why is it not a jury question if asking about to try to get these documents during all that time period?
Right, so
Isn't a jury issue of was he acting in good faith to perform?
So again, the issues between the share buyout and the LLC buyout are getting melded a lot.
Okay.
There was never a demand, written demand, or any written request that I've seen in the record for LLC documents. The demand that they made was to Fern Creek, the corporation, for documents. The documents that Dr. Jay was asking for before counsel got involved were for credit card receipts and things like that from Fern Creek. There was never an issue about LLC documents until the lawsuit was filed, and they included, you know, requests in there for LLC documents.
I guess suppose, though, that this gets back to the earlier questions. I think I was confused about that too, but if the LLC provision then, what I'm getting at is, did the trial court think there was some kind of time limit that's in the contract from that step 1 to step 2 that we're talking about now? Because my point is the court must have had some reason. Would you agree with me? Your friend for the plaintiff right now wants to do step 2 and beyond under that provision of the contract. I mean, do you agree that we're there to that point in their position?
So just to answer the first part of your question, the contract says that closing is to take place within 90 days. So that envisions that, you know, if we're going to do this 3-appraiser process, it's going to happen within 90 days. Certainly not 2 years down the road.
Okay, and that, okay.
Is there a provision that time is of the essence on that closing date?
I don't recall if there's a time of the evidence proof.
So that would be where the court is looking at that and saying, because what I'm trying to figure out is there some way that we can see how the trial court, as a matter of law, is just interpreting contract provisions and then looking at the undisputed facts here and saying, I can enter judgment as a matter of law. And you're saying, so that's, the trial court is saying, it all had to take place in 90 days and didn't, so I can say as a matter of law on these facts. I don't need to ask questions about what was going on in terms of the reasonableness of timing and things like that.
Is it 90 days from the delivery of the number from your client, or 90 days from either an agreement or the third appraiser's?
90 days from the date of notice. So
the date of
when we give notice that we want to exercise the option to purchase.
Thank you.
And so let me just clarify, we've got a share buyout, that has one way it's going to be valued. We have an LLC buyout that has a back and forth way. Is it evidence the fact that you've got an LLC buyout with a back and forth way that parties essentially assumed the risk of even bad faith in the calculation of the share buyout, such that that's why the trial court accepted that?
I think it's certainly evidence that they were aware of other options. There are other ways to do this,
So
certainly.
the contract controls even in the event of bad faith because the parties could have contracted otherwise? Or does the contract allow for a bad faith cause of action?
Well, I think good faith is built into every contract. But
Even if you have two different ways that you would value it, one being your company's accountant and the other being this back and forth process, there is still room, obviously, for a bad faith argument because a contract always implies bad faith, good faith, correct?
correct.
Okay.
So obviously, I'm not going to have as much time to spend on the big issue that I wanted, but so I think the big point here is that whether this court adopts anything from Delaware, which it doesn't necessarily have to do, but I do encourage you to read those Delaware cases that we cited in our brief in detail, because I believe what they do is provide a framework. We already have cases in North Carolina saying, here's what we do in North Carolina. Here are the circumstances under which we have found, a quote-unquote control group to be liable to a minority of shareholders. What the Delaware cases do is further provide a framework for recognizing that analysis. And I would point out, one thing that I didn't point out in my brief is that not only in Delaware do you have to have evidence of a control group, which they defined as, quote, some indication of an agreement to work together toward a shared goal, which may include, an agreement, a contract, or common ownership, but you also have to have a conflicted transaction. And I think that's what really delineates the requirements for, it kind of gives us the two-step process to say, okay, here's what we've done in Gaines, here's what we did in Loy, here's what we did in Norman. In all of those cases, there was not only significant evidence of common ownership between the defendants, but there was evidence of a conflicted transaction. Thank you.
All right, thank you, counsel. Any rebuttal?
Yes, Your Honor. We've sort of gotten into the weeds on authentication versus expert disclosure. At the end of the day, somebody has to, who knows what they're talking about, has to testify what happened. What was done to follow the contract and why? Whether that's an expert, whether that's a fact witness, somebody has to do that, and doing that includes authenticating the balance sheet that supposedly was looked at and applied. Nobody did that. They've not provided a single affidavit or deposition testimony saying, yes, this is the balance sheet as of year-end 2017. Nowhere in the record. And so it's not just, this is not a highly technical argument about procedural gotcha. There's reasons why we have these basic authentication requirements, which the law does require on summary judgment too. It's not just we have to authenticate things at trial. You're forecasting evidence at trial that you're going to have at trial, which means telling both the trial court and, for that matter, this court, that this is what it purports to be.
Forecasting the admissible evidence.
For the admissible evidence, that's right. And so, and that provides, it's important from a policy perspective, that provides some assurance to the courts that you're using documents that are genuine, that aren't just, whipped up out of nowhere by someone who doesn't know what they're talking about, or someone in this case who's not actually following the formula in the contract. Not anywhere in the record, and so we've argued a lot about this calculation report, but I don't think, and it's an interesting academic debate, but I don't even think we get into the finer points of that report because they've not done anything to authenticate it or the documents, the balance sheets, the financial statements that it says it relies on. A couple things I could hit, but first of all, there's a question about the timing for the practice, the Fern Creek shareholder agreement, although there's not explicitly a deadline saying, you know, you got to provide your appraisal by X date or whatever. If you look at it, and it certainly would be better to have all deadlines in there everywhere, but if you look at it, it does say that we're relying on the balance sheet, the last one from the last quarter in before the buy-sell event or the buyout event. Well, what does that imply? That implies that we're going to have a buyout within the next quarter or so, not a long drawn-out process where more than a year later, my folks are, Dr. J is forced to file a lawsuit to get his records to even evaluate things. And here we are, you know, 3-4 years after the initial buyout event where they've
Can I ask
invoked
a question?
it. Yes, ma'am.
So does the contract contemplate that Dr. J just has to accept what is put in front of him?
No, because, and I think Your Honor made it was a good question about how do the parties accept a risk of bad faith? Like, that's not just, good faith is a legal term implied into every single contract in North Carolina. Parties can't just dispense with that. Nor is there any evidence that the doctors even tried to get together and say, yes, you can defraud me, I give you permission to do that. That makes no sense. That's not, there's no evidence that happened here. So yes, there is good faith that's built in both to the contract issues as well as to the fiduciary duty issues we didn't talk about as much. And I will add very quickly in my 17 seconds left that it's not just the delay. It's the fact that they got together without notice to my client. They took his distributions, they used them to pay themselves administrative fees and to pay expenses of other businesses without any input from him. Thank you, Your
Let
Honor.
me ask one record question real quick, because it just keeps bugging me in my mind. It may not be relevant for anything, but the wrongful death case, is there anything in the record showing when that was resolved in terms of any of this timeline?
I'm not aware. May I consult very briefly with
If
my
you're
trial
right,
counsel?
yeah, because otherwise it's going to keep me up for the next couple nights.
Yes, sir. There's nothing explicitly showing when that was resolved. There are a few excerpts of trial testimony in the record which would sort of suggest when that was at least tried.
Okay, thank you, sir.
Thanks, Judge.
Appreciate it.
Thank
All
you, Your
right,
Honor.
thank you, counsel. Mr. Clerk?
All rise. The North Carolina Court of Appeals is now adjourned.
Great job. Great job. Same to you. You're next. I hope to do it again.